What is the arraignment, and do you actually need a lawyer to be present with you on your arraignment day? If you've been charged with any criminal offense in Georgia, whether or not it's a speeding ticket or murder, you're going to have an arraignment in your case. An arraignment's where you go in front of the judge. You can demand that the judge actually read the charges formally out to you aloud so that you know what you're charged with, or in most cases, you can waive formal arraignment upon the charges. That is what an arraignment really is about, is do you know the charges that you face, and would you like for the court in turn to actually inform you about those charges? You can imagine there was a day and time whenever people had a criminal case that was pending against them, and they may or may not have known what it was they were charged with. And that's the reason why we have the arraignment process, to begin the formal criminal case in which a person is aware, has knowledge of the charges that are pending against them. The vast majority of, for example, misdemeanor cases in Georgia, a defendant will waive formal arraignment or reading of those charges to them in court, and then they'll continue on through the process. At an arraignment, it's not necessarily that you have an attorney with you on that date. And it's not fatal to your case. It's not really going to harm you in any way unless you fail to take certain steps after your arraignment date. On the arraignment date, typically what you'll do is you'll go in there, you'll waive formal arraignment, which means waive formal reading of the charges against you by the judge or by the prosecutor in the case. It depends on different courts, how they handle it. And then you'll typically enter a not guilty plea. The not guilty plea doesn't mean that you're never going to enter a guilty plea in the case, but it does mean that for the time being, you're entering a not guilty plea and that your case is moving on towards a trial. Again, that doesn't mean necessarily that you're going to go to a trial, but it does mean that for the time being, that's what procedural posture that you'll be in. From there, the really important part that you need to be thinking about is that you only have 10 days from the date of arraignment to file motions for discovery, motions to suppress, special pleas, demurrers in your case if, for example, you thought the accusation or indictment was defective on some basis. That's really important. In the vast majority of my cases, motions are the basis upon which I get real traction in negotiating or getting the case dismissed. So really and truly, whenever you go in for the arraignment date, know that the important part, beyond simply showing up, entering your not guilty plea, is that motions and proper appropriate motions are filed in your case in a timely manner after the date of the arraignment. They have to be filed within 10 days. Some courts are more flexible about that, but then you never know. You might walk into a court, if you're unfamiliar with it, and have a judge in which they're really going to hold fast to that 10-day filing requirement. So make sure that you know about that deadline and how important it can be to your defense of your case going forward. If you have any questions, feel free to call me. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.